Marine, while you wait, I think you have the echo sound.
Oh.
You have the phone close to the computer, I think. Okay.
Okay. I see people connecting.
Yeah, I think like 5 more seconds and you can start.
Is it okay now?
No, you still have a background noise, but
I don't have anything next to me. That's the.
it's, yeah, there's an echo, I know. I don't know who is having the echo. We will try to, now, perfect, solved.
Okay. So I think we can start. Good morning, good afternoon, or good evening, everyone. Welcome to this online workshop on using the United Nations Optional Protocol to defend the rights of women and girls with disability. It is a workshop organized by the European Disability Forum and the International Disability Alliance. My name is Marine Uldry, and I'm EDF Human Rights Officer. Before we begin today, I would like to share with you some information and housekeeping rules for how the workshop will work. So the workshop will be 1 hour and a half without a break and will be divided into two sessions. We have interpretation in English, French, Spanish, and international sign. You can choose your language by clicking on the interpretation button at the bottom of your screen. And you can also pin the international sign interpreter. You also have live captioning in English and automatic captioning in French, Spanish, and Portuguese. You can activate the captioning in English by clicking on the subtitle button at the bottom of your screen. And you can also access the automatic captioning in French, Spanish, and Portuguese through an external link that was shared in the chat box. To choose your language, please open the menu. There's a flag icon situating on the left side of your screen. I think on the next slide, Anne-Sophie. Oh, okay, it's not there, but on the flag on the screen. Thank you already very much to the interpreter and the captioner for your work. If you have any technical difficulties, please use the chat box and my colleague Raquel will help you during the webinar. We'll post useful link in the chat. And for the Q&A session, so there will be 2 times to ask question. You can use the Q&A box to send your question. You can send them either anonymously or put your name. Everyone will be able to see the question sent, and you can also vote for the question if you have a similar question. If you want to ask a question or make a comment orally, please write it directly in the Q&A box, and we'll give you the floor and unmute you if you want to speak. The webinar will be recorded and then be published on EDF website, and we will also send the PowerPoint presentation to all the participants. So I think that's it from my side. Now I will give the floor to Ana Pérez Narváez, who is the Vice President of the European Disability Forum and Vice Chair of the United Nations Committee on the Elimination of Discrimination against Women. And she will be moderating this webinar. Thank you.
Thank you very much, Marine. Bienvenidos, bienvenidas a todos a este webinario organizado por la Alianza Internacional de la Discapacidad y el Foro Europeo de la Discapacidad. Felicidades a estas dos organizaciones por organizar este importante encuentro, esta importante reflexión en un momento sumamente de urgencia en relación a la situación de las mujeres y niñas con discapacidad, en donde como consecuencia, entre otras cosas, de esta pandemia que se sigue viviendo, muchas de ellas están en una situación muy complicada, en donde apenas tienen acceso a la justicia. Por eso, pensar en los protocolos como un mecanismo de Naciones Unidas para hacer llegar estas situaciones de discriminación que sufren especialmente estas mujeres y niñas, es de extremada importancia. Hoy hablaremos de las comunicaciones individuales, sobre todo en relación con el protocolo de la CEDAW y el protocolo de la CRPD, pero también hablaremos de las posibilidades que ofrecen estos protocolos para los países que los hayan ratificado, las posibilidades de hacer investigaciones en los países a propósito de cuál es esa situación. Me gustaría agradecer también especialmente a Marín y a las compañeras del secretariado del EDF, también a Sofía, por supuesto a Raquel, a Catherine, por todo el trabajo preparatorio. Excelente, de verdad, excelente, millones de gracias. Y quiero agradecer también a las compañeras, a mis compañeras del Comité de Mujeres, del Foro Europeo de la Discapacidad, que es el órgano consultivo que tenemos dentro del movimiento de la discapacidad, del Foro Europeo de la Discapacidad, para que las voces de las mujeres y de las niñas con discapacidad y de las madres y cuidadoras de los familiares con discapacidad se tengan en cuenta. De verdad, a todas ellas que están hoy aquí también con nosotros y con nosotras, muchísimas gracias por ese trabajo que están haciendo ellas y otras muchas organizaciones también en el plano nacional, especialmente para reportar en distintos órganos de derechos humanos, ya no solamente de Naciones Unidas, también, por ejemplo, del Convenio de Estambul ante el Grevio, sobre la violencia, la discriminación que sufren las mujeres y niñas con discapacidad especialmente. Me gustaría que, como se va a grabar este webinario, también estuviera disponible para muchas mujeres que hoy no pueden seguirnos porque no tienen las suficientes herramientas, a lo mejor de alfabetización digital, para poder utilizar Zoom o los sistemas de Internet. Yo confío también en el trabajo de las organizaciones de personas con discapacidad, en el trabajo de las organizaciones de mujeres en general y muy especialmente confío en el trabajo de las organizaciones de mujeres con discapacidad para que se utilice esta grabación también para que se pueda poner disponible para todas esas mujeres. Nos queda también a nosotros mucho por hacer, para hacer que nuestro mensaje, que nuestras herramientas de empoderamiento, de formación, lleguen, por ejemplo, a las mujeres con discapacidad intelectual, con parálisis cerebral, mujeres sordociegas, mujeres que necesitan sistemas de apoyo a la comunicación por diferentes razones. Les pedimos perdón a todas ellas por tener todavía estas barreras, pero pedimos también a las organizaciones que estáis hoy aquí, que nos acompañéis en esta tarea, que podáis ofrecer después, en otro momento, esta grabación también a todas esas mujeres por las que tenemos que seguir luchando y trabajando con ellas, nunca sin ellas. Para mí es un placer dirigir este webinario, que además se ha dividido muy bien en dos partes. En la primera vamos a escuchar a una oficial de derechos humanos de la Oficina de Naciones Unidas de los Derechos Humanos, a Teodora Krumova, que nos va a hablar precisamente de la importancia de considerar estos protocolos, especialmente el protocolo de la CRPD y el protocolo de la CEDAW, no solamente para lo que es, como he dicho anteriormente, la presentación de comunicaciones individuales, sino también para abordar el tema de cómo iniciar a lo mejor una investigación a un determinado estado por una violación constante, sistemática de derechos humanos contra, en este caso, de mujeres y niñas con discapacidad. Después de Teodora vamos a tener un pequeño tiempo para que nos hagáis llegar vuestras preguntas. Teodora, es un inmenso honor recibirte en este en torno en este webinario, en donde tu mensaje es importantísimo para empoderarnos y para que nuestras realidades y violaciones de derechos humanos, las nuestras, las de las mujeres y niñas con discapacidad, las de las madres y cuidadoras de personas con discapacidad, lleguen al sistema de derechos humanos de Naciones Unidas a través de estos dos protocolos tan importantes. Bienvenida, te escuchamos.
Thank you very much for the warm welcome. I hope everybody can hear me well. I will speak in English, and I'm very grateful to be with all of you today and to be given this opportunity to inform you about the different possibilities you may explore through the international human rights mechanisms, and especially two very interesting procedures, the individual complaints procedure and the inquiry procedure. So now I'm going to share with you my presentation, and I hope everybody can see it. Yes?
Yes, perfect, Theodora. Thank you so much.
Thank you very much for the feedback. And I hope that the virtual world will not create problems for us, but just the opposite, will give us the opportunity to communicate. And again, I'm extremely thankful to see that more than 100 participants are willing to work for the rights of women with disabilities and girls with disabilities. So I'm about to try to start with the slides, which was working before, but for some reason not working now.
Sorry, Theodora, but we cannot hear you very well. I don't know if you can perhaps stay closer to the mic, perhaps, could be useful.
Can you hear me now?
A little better. Thank you.
Yes, a bit better. And you can see the screen also. Yes? Yeah, okay, thank you. So first of all, starting from the very beginning, you are aware of the existence of international human rights treaties, covenants, and conventions. However, we also have, as part of the international human rights law, optional protocols complementing some of the conventions. In our case now, today, we are going to focus on CEDAW and CRPD and on the two optional protocols. And usually protocols are on their own right also treaties, and they may provide for procedures with regards to the main treaties, the conventions, or they may address a substantive area related to the treaty. When we talk about the optional protocols to CEDAW and to CRPD, they are also open to signature and ratification by the different member states to the main conventions. I'm underlining this because when you are planning perhaps your action and planning to submit material for an individual complaint or for inquiry, first of all, of course, you have to be sure that the state party has signed and ratified both the convention, the main convention, and the optional protocol that allows these two procedures, the individual complaints procedure and the inquiry procedure. So as you can see, these optional protocols are developed to further the possibilities under the main treaties. And in a way, they strengthen CEDAW, the convention, and CRPD, and they give more tools in the hands of the committee members to address violations of women's rights, in our particular case, women's and girls with disabilities, by establishing these two additional procedures. So here, I just wanted to show you, and my slide represents the world with all the states in the world. And in different colors are the states that have signed and ratified the optional protocol to the Convention on the Elimination of all forms of discrimination against women. And those countries are depicted in green. Sort of, you would have the green light for your action in support of women with disabilities rights in these parts of the world. However, unfortunately, you can see perhaps that there are some countries in gray, and those countries, those states have not signed and ratified the convention or the optional protocol. And I can give examples of states like the US or China or India, or states in the Middle East, or some states in Africa, where unfortunately it would not be possible to use these procedures. So now, going more concretely and trying to explain the individual complaints procedure cycle. The cycle, if you can imagine a cycle, is from the beginning, from when you submit an individual complaint. Then there is a process I would call as filtering. And colleagues working in the Office of the High Commissioner for Human Rights and supporting the committee members, the independent experts, will initially review. And this is an important phase, because in this initial phase will be decided whether to accept the individual communication and to register it as a case. Once it will be registered as a case, and perhaps if there are also interim measures requests, this request will be granted, then the life of the real case with the committee, be it CEDAW or CRPD, for the case begins. There is a period of exchange of communications between the parties, the state party and the individual or the group of individuals. This takes usually a couple of years. The state party is requested to present observations to the initial submission, the initial complaint. After that, the authors are requested to introduce their comments to the state party observations. So as you see, this is a round of exchanges. And eventually, when the case is procedurally ready, the committee will proceed to the examination of the individual communication in a private session. I have to underline here that the procedure is confidential and that every author may from the very beginning request anonymity. But we will elaborate a bit further later on the anonymization of the author, the victim in the case. Later on, when the committees adopt their findings, their views of violations, these views and decisions will be public. They will be published and made public, but however, the author, the victim's name can be anonymized with an XZ or just acronym. Once the committee decides, each case of a violation enters the last phase, the so-called follow-up procedure. It's a follow-up phase to the decision in which the state party is given 6 months to respond to the committee's findings and recommendations in the particular case, and to send exact information what kind of measures it has taken in order to remedy, be it measures related to the individual complainant, personalized, or be it more measures of a general nature. Now I will talk about something that I believe may be important for those of you interested to bring an individual communication. There are several criteria, and because the procedure is quasi-judicial, it's quite legalistic. It is important that you make sure before bringing an individual communication before CEDAW or CRPD that all these requirements are met. First of all, I have shared with you a link. When you click this link, you may check whether the state party against which the communication is introduced has recognized the convention, but also the optional protocol. This is important because without the acceptance by the state party of the optional protocol, we cannot follow up this path, these procedures, and we have to think perhaps about other ways how to utilize the international human rights mechanisms. Then, of course, we have to think whether the facts we present to the committees have occurred after the entry into force of the convention in the respective state party. This requirement, it's called ratione temporis. Usually the state party will argue if the violation has occurred before the state party has accepted the convention. However, there are some exceptions, and they are called continuing violations. In this case, the facts, the violations may have started, the occurrence may have been before the entry into force, but they continue after the entry into force. Like this, we can bring this case to the attention of the committees. Also, the individual communication must be presented by a person or a group of persons, and they have to have the so-called victim status. They consider themselves to be a victim of a violation of a right under the convention. This leads me to the next point, that it's not possible to introduce actio popularis under this individual complaints procedure. So it's not possible just to claim in abstracto, that certain law is discriminatory. There should be a link established between the individual and this law, policy, or practice. The individual should be a victim. Also, the complaint could be introduced by a representative. It could be a lawyer, but also it could be a non-lawyer or a supporting NGO, non-governmental organization. What the committees require for this procedure is a written authorization, just signed, but it doesn't need to be legally certified by a notary or anything like that. And also, we realize that there are situations, for instance, if the person is in detention and it's not possible to establish direct contact, this needs to be explained, just explained why there is no written authorization on behalf of the victim if the individual communication is brought by a representative. Further on, I continue with the registration criteria. And something important is that the rights claimed and involved must fall under the scope of the convention. Otherwise, they are not protected, and the individual complaint may happen to be out of so-called ratione materia. Also, the committees cannot review the judgments by national courts unless these decisions clearly violate rights under the convention, because the committees are not a fourth instance coming on top of the usually three instance national systems. The committees cannot assess facts and evidence, or cannot enter into disputes or matters between private individuals. Obviously, we have to have a state party involved and violating the rights of an individual. For instance, the committee would not enter into examining the guilt or the innocence, like the criminal responsibility of an author, and they will look into domestic court decisions, but will intervene only if it is established that they have been arbitrary or they have led to clear injustice. Very important rule is the next one. All available domestic remedies, administrative and or judicial, must have been exhausted prior to bringing the complaint before the CEDAW or the CRPD. Or, again, the exception would be for the authors to demonstrate that the application of such domestic remedies has been unreasonably prolonged, or in other way, the domestic remedies have been unavailable or they have not been efficient. And there is jurisprudence, but also there is jurisprudence in the direction that an author mere doubts about the effectiveness of domestic remedies do not absolve the author from exhausting the remedies. So to sum it up, for this procedure, it's very important to exhaust initially all the available and considered effective domestic remedies in the state party. In that sense, the procedure, the international procedure, is subsidiary. Next requirement is that the same complaint have not been examined or be examined in the moment under another procedure of international investigation or settlement. For instance, the European Court of Human Rights or the Inter-American Court, or in the African system, basically the regional human rights instruments. This requirement goes in the direction of the principle of legal economy. If another body or instruments they have already reviewed or are in a process of reviewing, then the committees will refrain from taking on board this individual communication. Also, importantly, when drafting the submission, there should be sufficient details as to the facts of the case and as to how the rights of the individual under the relevant convention have been violated. Enough so that the committee can take a decision based on the facts submitted. So ideally, my advice is when drafting is to present the facts clearly in a chronological order and to give enough details and explaining also which article of the conventions have been violated, and if so, why you consider that they have been violated. Sometimes, let's say, if the legal classification may not be exact, the committees will look into the facts and the claims, and they may decide to reclassify. But what's important is that the key facts of the violation are there, and the explanation why one believes that the rights have been violated are there. If something is not going in the right direction, sometimes my unit, the Petitions and Urgent Action section, may send a contact letter to inquire for additional information in order to be able to help the authors submitting the complaints.
Teodora, we don't have much more time. Please conclude your intervention. Thank you very much.
Okay, I will go very quickly then. I will just mention that interim measures requests are also possible to avoid irreparable harm to the victim. Those are requested mostly in deportation cases or death penalty on refoulement cases or evictions. Also, I have here two examples under CEDAW and under CRPD. It's Chobanu versus Moldova. Another case, NL versus Sweden, CRPD, and the case Z versus Tanzania. But I know that other colleagues will elaborate furthermore on those cases. So that's why I will quickly go to the practical guidelines. In the presentation, you have the new individual complaints form, and also a guidance note how to fill up this individual complaints form, and this can help you in the process. Also, there is a fact sheet 7, revision 2, which explains in detail also the procedure. Would I have a little bit of time also to talk a couple of minutes about the inquiries procedure?
Teodora, but please, very quickly, because if not, we don't have time for questions from our colleagues who are participating in the webinar. So please, 2 minutes.
Okay. I will just quickly introduce the inquiry procedure. It is important because it gives the opportunity to conduct inquiries into grave and systematic violations, in our case of women with disabilities, human rights. It allows investigation. That's one step further. It's very useful to reflect the systematic nature of some violations, the widespread violations, and gives the opportunity to communicate findings and make recommendations when it comes to more structural issues, and sometimes allows the committees to undertake a country visit. Of course, this happens always with the consent of the state party. At every stage of this inquiry procedure, of course, the consent of the state party should be taken. How does it start, the inquiry procedure? With receiving by the committee of reliable information that indicates to grave or systematic violations. Then the committee may designate one or more of its members to conduct the inquiry, and the committee transmits its findings to the state party. Within 6 months, the state party concerned submits observations to the committee. So you see, it's again a process, and everything is conducted confidentially. The state party has to present a report to the committee and inform within 6 months periods about the measures taken in response of such inquiry. And also I want to mention that both working groups on inquiries and individual complaints are composed by 5 members, and they respect equitable geographical representations. They have meeting time, respectively 10 days per year for the working groups on communications and 6 days for the inquiry procedure. And they draft and adopt views of violations and report when it comes to the inquiry procedure to transmit to the entire committee. And then the committee, of course, will decide. And if you want to know more about grave and systematic, perhaps I think you will receive my presentation and you will see all the steps in this inquiry procedure. And hopefully when there is a visit to the territory, this is also very empowering. And hopefully after COVID, these activities will resume. And all the findings of the inquiry eventually are made public on the webpage, be it of CEDAW, of CRPD. And I have here given you examples of 7 inquiries conducted by the CEDAW committee. And
Teodora, sorry about that, but we don't have more time. We are nearly at the end of this session without any contribution from our participants, and I consider this fundamental. So thank you very much for this important information that you were providing for all of us. But now I open the floor for questions or concern in this regard. Perhaps we can take all of them and then we can offer perhaps the answer by written format. Could be also a possibility. So Marin, could you please tell us who is asking for the floor and if we have comment in the chat, please?
So we received written questions so far. So maybe I can start with 3 of them.
Please.
Let me just check because I have a problem with the interpretation. So the first one concerns the case that is being brought at national level. Does the case need to be brought against the states, Or if, for instance, it's
I'm
okay.
sorry, but the French interpreter is on the English channel. Can you please?
If the case is being brought, for instance, against a specific hospital, can it also be then being brought to the CEDAW or CRPD committee? So that's one question.
Yeah.
Another question is, what is the role of the committees? So for instance, the CRPD committee in the implementation phase of a decision. Then we have a third question about the standards that are being used by the committee as strong evidence to determine a systematic violation in the given country. So are there specific standards that are being used to determine that it's actually a systematic violation?
Thank you very much, Marine. Apart from this question, I have another one, which is how the committees, Teodora, consider legal capacity as a substantive request for considering admissible one of the individual complaints. So could you please offer us some answers for all these questions? Thank you.
Thank you very much. Okay, so I will go backwards. The first question was considering exhaustion of domestic remedies and whether, for instance, domestically, the case could be brought against a hospital, right? So I can say yes. Of course, there are some perhaps differences between private hospital and state hospital, but I can give an example of a CEDAW individual case in which CEDAW recently found a violation. The case was brought by two Roma women against Northern Macedonia with the help of an NGO and with the help of the use of testers to prove discrimination and discriminatory practice of a gynecologist. And the gynecologist, she has been a private MD operating a private medical facility. However, she was operating in vicinity of neighborhood where Roma women were living, and she was offering her services without delay and taking patients from the non-Roma community, while she refused to take women from the Roma minority community. So in this particular case, two cases actually, CEDAW found discrimination, CEDAW found a violation. And domestically, the case was brought, the case of discrimination was brought against this private MD, medical doctor. So this is concerning the first question. Then I think there was the question on the implementation, the role of the committees when it comes to the follow-up, the implementation of the decisions. This is the so-called follow-up procedure. This procedure follows the same logic. The state party, after the committee adopts views of violation, is given 6 months to come back to the committee with observations as to what kind of measures the state party has taken, first individually to satisfy the claims of the individual authors, and then general measures. Depending on the recommendations, for instance, issued by, let's say, CEDAW or CRPD. Then these responses are assessed by the committee, and the committee produces the so-called follow-up reports. And in these reports, the observations, follow-up observations by the member states and the comments, because the authors are also given the opportunity to comment, are summarized. These follow-up reports are eventually public, and the committees grade the response and the measures taken by the state parties, and it may be satisfactory or unsatisfactory, or sometimes partially satisfactory. So this is the role of the committee in this assessment and grading. However, later on, of course, the Office of the High Commissioner for Human Rights tries to continue the dissemination through regional and country offices. And all the state parties actually, one clear measure, they are requested to disseminate broadly the views of the committees. Then I think there was a question about standards, or I'm not sure. Could you repeat, please?
So the question was whether you have an idea about the standards used by the committee.
Thematic and grave, right?
Exactly.
Yeah.
Teodora, but think about just 2 minutes because we need to go ahead with the program.
Yes,
Please.
yes. So the committee consider violations to be grave when they are likely to produce substantial harm to victims, and the committees, the standards, the committees may take into account the scale, the prevalence, the nature, or the impact of the violations. And when it comes to systematic refers to the organized nature of the acts leading to the violations. So organized nature, and the improbability of their random occurrence. So when we are talking about systematic, it means that it's organized. The state party in an organized manner acts, and acts in such a way that this leads to violations. Yes, and I think there was another question, right?
There was 3 questions.
Yes, it was my question in relation with legal capacity.
The legal capacity. Yeah, we have had an interesting case submitted to CRPD on behalf of a French citizen who was on life support completely in vegetative state, and it was submitted by part of his family. Interim measures were requested in order to sustain the life support of this individual and were granted in this case. And the case was submitted by the mother and the father and several siblings of the individual. However, on the other side of the family, the wife of the individual claimed that she has the guardianship nationally, and therefore she is entitled to request or not request. So this is a complicated case. It was also submitted to the European Court of Human Rights. The regional body denied granting interim measures. But just to tell you that sometimes we need to look into the national documentation. Who is the guardian? Because there are several family members. And sometimes, of course, we had a case with CEDAW submitted on behalf of a deceased mother and children, a person with mental disability. She was killed by her husband. It was a case against Finland, who also had disability. And the case was brought by the parents of the deceased woman with the help of an NGO. So the parents were considered having status and ground to bring the case.
Teodora, I think we need to stop here because we need to go to the other part of the session. Sure. And I would like just to highlight for information for our participants that the CRPD committee has already reconsidered the rules for individuals' communication in relation with legal capacity, which is great because a person without legal capacity recognized in their country can present a complaint to the CRPD committee, and that can help also for other committees to do the same. So I think this is a very important improvement in relation with Article 12 of the CRPD. Teodora, thank you very much for your presentation and the information provided here today. Now we go to the second part of the webinar, which is learning from experience. And learning from experience, taking in mind that here we are especially focused on the CEDAW protocol and the CRPD protocol. For the first case, so the CEDAW protocol, we have Ishita Dutta with us. Welcome, Ishita. Ishita is program manager at the International Women's Rights Actions Watch, Asia Pacific. And you have the floor. Ishita, thank you very much.
Thank you very much, Ms. Anna Pelaez. It's a great pleasure to be with all of you here today. Thank you for having me in your space and for letting me add my voice to the struggle for rights of women with disabilities. So I'm speaking to you as a Global South feminist activist from an organization that has worked closely to support NGOs to engage with the CEDAW committee. And so my intervention is based more on experience. So without further ado, I will talk to you about what the optional protocol to CEDAW is. And without repeating much of the important information that Theodora has already shared with us, I wanted to highlight that the optional protocol entered into force in December 2000. But as Ms. Anna Pelaez highlighted the real importance of civil society activism in her opening remarks, I wanted to flag that this adoption happened as a result of very strong activism from women's rights activists around the world who wanted a specific mechanism for enhancing access to justice for women's rights under CEDAW at the international level. So the optional protocol has this history of women's rights, of being born from women's rights activism. So moving on, you've already heard about the communications procedure and the inquiry procedure. And I just wanted to stress that this is both these procedures are quasi-legal and they might seem very daunting to some of us as activists who engage with the law or use the law as part of our advocacy. But we should always remember that these procedures were created for rights holders to bring human rights cases, right? So even if they seem technical and complicated, there are organizations like IRA Asia Pacific as well as IDA and EDF who can help you all to navigate this process. So I'm not sure, I think it's taking a minute for my visual to load on the screen. Just give me 1 second. My presentation will be shared with all of you, but I have shared basically 2 tables that can kind of help you figure out as a tactic when to use the optional protocol, right? And you can think about questions such as, what is the change that you're trying to make, right? And it is a tactical question of making a change to a law, changing institutions, or changing the culture that is impacting women's rights in your country. And an important part of the analysis is also why the women's rights violation is happening, because this has to be illustrated very clearly to the committee. And again, as Theodora has referenced, we know that for individuals to seek remedy, we have the communications procedure, but for more systemic remedies, it's useful to utilize the inquiry procedure. But there may also be issues such as confidentiality or security of the person for whom remedy is being sought after. that results in, that might impact which mechanism you decide to choose. Another thing I wanted to flag is that, of course, this is a resource and time-intensive process for activists, so that must also be taken into consideration. Who is supporting us in the country as we undertake this strategic litigation? Can we get support from other human rights organizations? Will the government, will there be reprisals if cases are raised? So these are all strategic considerations that must be thought about. Without going further into procedural information, I think I just wanted to highlight the importance of the optional protocol as also a mechanism that can be used to progressively interpret women's rights. And I think the importance of this webinar is also to draw the connections between CEDAW and CRPD and see how we can bring the rights under one convention to have a bearing on another convention. And a very good example was just given about legal capacity, right? So when you're thinking about which women's rights violations to bring under the CEDAW optional protocol, you must bear in mind the whole body or the universe of the international human rights law system. I think we have spoken about all of these procedural issues. So I will jump straight away to highlighting a few cases concerning rights of women with disabilities as examples of what has been decided by the committee. So one of the first cases concerning domestic violence that was submitted before the CEDAW committee was called AT v. Hungary, and it was decided in 2005, and it concerned a person, AT, who suffered domestic violence from her husband, did not receive adequate legal protection, and she could not access a shelter as the entire country did not have one that was equipped to meet the needs of a child with disabilities. And the committee gave individual remedies to AT, requiring the state of Hungary to take immediate and effective measures to guarantee the physical and mental integrity of AT and her family. But they also asked the state to introduce a specific law prohibiting domestic violence in Hungary, which comprehensively looked at all the issues that women need when they need protection from domestic violence, such as protection and exclusion order, support services, shelters, etc. The second case I wanted to highlight was RPB versus Philippines. And this was also a case concerning a young woman with disabilities who was 17 years old when she was raped by her neighbor. And the trial court in the Philippines acquitted the accused based on gender stereotypes and myths. And they did not consider the vulnerability of RPB as a deaf girl or provide reasonable accommodation to her, such as providing a sign language interpreter. And all of this took 5 years of a judicial process in the Philippines. And the committee recommended that the Philippines state provides RPB with reparation, counseling, and barrier-free education with interpretation. And it also asked the state to review its rape laws to decenter use of force and put at its center the lack of consent, and also ensure that procedural issues such as free and adequate assistance of interpreters at all stages of legal proceedings are ensured whenever needed. So I will just pause to highlight the importance of this case is that the committee did not just stop at saying that access to justice should be ensured at RPB, but the committee is invested in ensuring that RPB is able to live her life as a woman to the fullest extent beyond this case, and therefore remedies such as the access to barrier-free education with interpretation are really important. So when we are considering as advocates what type of remedies we want to seek, we should have this structural and systemic analysis in mind, because the committee is also actually thinking along those lines. The third case that I wanted to highlight was Chobanu versus Moldova, and this is a recent case, and this concerns the case of Natalia, who resigned from her job to care for her child with disabilities, as the only alternative available to her was placing the child in a state institutional facility for care. So eventually she applied for a social security pension from the state, and the period that she spent in childcare was excluded in the calculation of her social security pension. And so she received a very small amount. And again, when she brought the case to the CEDAW committee, the intersectional discrimination faced by a woman who has the primary responsibility of being a caregiver to a child, and who doesn't have much opportunity to get into gainful employment after a long break, and the fact that caregiving is the main, it's assumed in most of our societies that women are going to be the caregivers. These facts were taken into consideration by the CEDAW committee to ask the state of Moldova to recalculate the author's social insurance pension, to award her compensation for denial of rights to social insurance, and reimburse her legal costs. And systemically, the CEDAW committee asked that the state remedy the situation of all women who would have been in a similar situation and ensure that there is availability of adequate services to allow mothers of disabled children to remain in employment. And if I have one more minute, I will like to go very quickly to an example of an inquiry case. This is the most recent inquiry concluded by the CEDAW committee in 2019, and it concerns the United Kingdom and Northern Ireland. Apologies for the typo on my slide. So why I wanted to highlight this was because a specific question was asked about the success of an inquiry case. And I think this is a really, really important case in that regard, because this inquiry was instituted as against the denial of abortion and criminalization of abortion in Northern Ireland. And the CEDAW committee, after conducting an inquiry visit to Northern Ireland, found that these restrictions amounted to grave and systematic violations of women's rights. And this inquiry report was one of the many significant advocacy initiatives that were undertaken by groups in Northern Ireland that actually led to the decriminalization of abortion in Northern Ireland in October 2019. So I wanted to leave you all with this hopeful note, and my presentation will be shared with you. And I'm happy to answer any questions that you may have here, but I hope that you will also be in touch after this webinar. Thank you so much.
Ishita, thank you very much for this important information, for this perfect revision that you have made in relation with this consideration of situations of women with disabilities under the CEDAW protocol, which is great. And also thank you very much for sharing with us also your presentation, which is great for the people who are interested to know a little better the information that you were provided. So let's go now to the, as good practice, to the consideration of women and girls with disabilities under the CRPD protocol. And for that, I welcome Juan Ignacio Pérez Bello. He's Human Rights Advisor at the International Disability Alliance. Juan Ignacio, it's a pleasure to offer the floor today here with all of us for this important issue. Welcome, Juan Ignacio.
Thank you very much, Anna. The pleasure is very much mine. I'm very happy as part of IDA to have collaborated with you and with the European Disability Forum in putting together this event. We are also particularly glad to share information on these key tools to advance the rights of persons with disabilities, and in particular women and girls with disabilities through the use of all these procedures that we are discussing today. I would like to start to share my screen to have a PowerPoint presentation. So I believe that now should be working. So in this first slide, I just want to put the things a little bit in perspective with the big picture of ratifications of the optional protocol to the Convention on the Rights of Persons with Disabilities. Out of the 182 countries that ratified the convention until today, 97 have ratified the optional protocol. That's why the recommendation by Ms. Krumova is very important to double check on what has your country done by now. I will focus on the use of the individual complaints procedure under the optional protocol to the CRPD. I can say that by now there have been 44 views adopted by the CRPD committee and 3 cases, including 3 cases discontinued. But there have been in the recent session 3 more that still remain to be publicized. Those decisions on individual cases have relate to only 18 countries out of the great number of countries I mentioned that have ratified the protocol. This includes 4 countries from Latin America, such as Argentina, Ecuador, Brazil, and Mexico. Some countries in Africa, such as South Africa and Tanzania. But many European countries, and especially the country that has more related communications is Australia. This calls for enhanced use of the protocol also from organizations from other countries, as the participants here in the webinar probably come from. I would like to highlight this point, very important, that Ms. Krumova shared with us about the admissibility requirements that we always need to recall when we are facing the reflection on whether or not we would like to use the optional protocol. And especially, I would like to highlight this because it's probably the more burdensome, which is the exhaustion of domestic remedies. For that requirement, there are 3 main exceptions that I would like to always highlight. One is if there are no remedies available. The second one is if the application of those national remedies would be unreasonably prolonged and or would be unlikely to bring effective relief. No prospect of success is the typical phrase used by the CRPD committee. I highlight this because it's usually important to see if there are opportunities to employ the optional protocols even before or having exhausted all the domestic remedies. And connected to this, highlight again the importance of the interim measures mentioned by Ms. Krumova under Article 4 of the optional protocol. From IDA's side, at the website of the International Disability Alliance, we have 2 sections of the website devoted to this optional protocol. To facilitate the access to this area of work of the CRPD Committee for dissemination, one is the website on individual communications, which includes short descriptions of these 44 views adopted until today. And for each of those cases, there is a summary of the views adopted, which also can lead to the official version online in the website of the OSCHR. We do this because sometimes it's difficult to access this information on the official websites. And we also provide a snapshot of each case with that little short description that helps very much to get acquainted with what the CRPD committee has been saying under this procedure. We also have a website on the inquiry procedure with summaries of the 3 reports under this procedure by the CRPD committee, which relate to the United Kingdom of Great Britain and Northern Ireland on the issue namely of mainly of social protection, to Spain on the issue of inclusive education, and to Hungary in connection with institutionalization, a topic that will be addressed by, especially by the next speaker, I believe. All this to highlight as well that you note that this procedure has been utilized only until now, or mainly, by 3 European countries and not that much from other parts of the world. Just one point of clarification, I won't go in detail into this, but for those countries that might not have ratified the optional protocol, the section K of the working methods of the CRPD committee allowed for a specific procedure that could be consulted with under the title Early Awareness and Urgent Action Procedures. This is not very known as a procedure, especially since the mandate of the Special Rapporteur on the Rights of Persons with Disabilities was created, and who has absorbed to some extent this function. But in this period of time in which maybe the CRPD committee doesn't have that much country-based activity, and this can be a useful procedure to trigger. Of course, now going a little bit more into the substance, the CRPD Convention has a very important article on women with disabilities, which is Article 6. Most of you might be very familiar with it and with its text, which is now projected in the screen. It is a cross-cutting issue, cross-cutting article, that applies in connection to all the articles of the Convention. And of course, it's very important to highlight in terms of substance as well that the CRPD committee has adopted General Comment number 3 on Article 6, in which, as far as I recall, Ms. Ana Peláez has been very much involved in that period. This is to put the thematic scope in connection now with the gender dimensions of accessing and utilizing these procedures, which is on what I would like to focus now. Until this moment in the conversation, we have been discussing more procedural and a little bit of substance under the CEDAW Convention. The question now is, what is specific to women with disabilities when accessing these procedures? How is the gender dimension of the different violations of the rights of persons with disabilities grasped by the CRPD committee, and how we could make use of that until now, for now. The CRPD committee has dealt with 2 cases in connection to this, and one is Z versus Tanzania from 2019. The case concerned a woman with albinism and a single mother who was attacked by several men that amputated her one arm and mutilated the other. Horrendous aggression. The attackers were detained and later they were released because the victim's testimony was invalidated under the argument that she was visually impaired. Unbelievable, of course. The committee found discrimination on the basis of her disability because of the violence against people with albinism is a generalized practice in the state, and disability-based discrimination owing to the impunity for the violent acts that she suffered, meaning the state's investigation was not acceptable and led to their release. After the incident, the victim was not provided with assistance for her rehabilitation and reintegration. And based on this, the committee found violations of the right to equality and non-discrimination, the right to be free from torture and inhumane treatment, the obligations under Article 16 on prevention of violence, abuse, and exploitation of persons with disabilities, and the personal integrity. But now comes in the following slide the gender-based analysis that the CRPD committee did when deciding this case, in which the CRPD committee verified that the author was a single mother of a small child and was pregnant. The author, as a consequence of the attack, suffered a miscarriage. This resulted in her isolation from the community, amounting to gender-based discrimination. None of these elements was considered during the national procedures to address discrimination. Invisibilization of the impacts suffered as a woman amounts to gender-based discrimination, contrary to the Article 6, which requires recognizing and addressing multiple discrimination and ensuring the full development, advancement, and empowerment of women for guaranteeing the exercise of their rights. After these verifications, the CRPD committee concluded that there was also a violation of the Article 6 on women and girls with disabilities in connection to the rights previously considered that I mentioned before. This was only possible because this point was very much stressed by the complainant when submitting the complaint. On the contrary example, in another more recent case, and this is almost the last slide, please do not cut me just yet. There was a recent case of a woman from Iraq applying for asylum in Sweden after a mental health diagnosis. And then she was diagnosed with depression with psychotic features, between quotes. Her asylum application at that point, based on threats from relatives in Iraq due to a relationship she maintained with a man, was rejected by the authorities of Denmark. And then this woman from Iraq initiated any legal and administrative procedure possible to stop her deportation, but now based on the deterioration of her mental health. At some point of her complaint, she alleged under Article 6 on women and girls with disabilities that, I quote, "As a woman without a family network in Iraq, her special vulnerability as a woman with disability is to be recognized under Article 6 of the Convention." This was her only elaboration on this point. The conclusion, unfortunately for her, on this point was that for the committee, this claim, this point from her submission, her complaint, was inadmissible because it was not sufficiently substantiated. One needs to explain in which way one considers there is a gender dimension connected to the violations of the rights described before. The committee said at some point, and I quote, "The author has not provided any additional specific information or argumentation to justify her claims under Article 6, nor has she explained how these claims would amount to a real and personal risk of irreparable harm if she were to be removed to Iraq." This, the committee said, rejecting this claim. Nevertheless, the committee found a violation to other articles on the convention, asking the state, because the state did not consider whether the woman would find suitable mental health care back in Iraq.
Thank you very much, Juan Ignacio. Unfortunately, we don't have more time for your intervention. We were foreseeing 10 minutes for each. We need to have the chance to give the floor to participants. Sorry about that. Thank you very much for.
Thank you very much to you, for sure, no problem.
Okay, thank you very much for this important information about the consideration of some women with disabilities under the CRPD protocol. Now let's go to a very important issue also linking with the protocol, which is the situation for inquiry, for investigation of a state party when there is a violation of human rights in this case for women with disabilities. And in this moment, I would like to pass the floor to Anne Campbell. Anne Campbell is the co-executive director of Validity Foundation, and she will be with us today telling us her experience in inquiry for the CRPD protocol. Anne, welcome to this webinar. You have the floor.
Thank you very much for giving me the opportunity to speak with you all here today. Firstly, I would like to address the context and the reasons why Validity Foundation submitted a request to the Committee on the Rights of Persons with Disabilities under the optional protocol for the initiation of an inquiry into violations in Hungary. Then I will just set out briefly a couple of the main arguments that we made in that request, together with the findings of the committee. I'll then briefly outline the process in practice, what happened, as well as the impact of the inquiry and the follow-up activities. So we submitted the inquiry in March 2017 under Article 6.1 of the protocol. The inquiry document itself was nearly 60 pages with an executive summary, and it included recommendations which we put up front at the beginning of the document as well as at the end. Our main concerns were around Articles 12 and Articles 19 of the Convention on Legal Capacity and Independent Living, which of course are underpinned by Article 5 on the prohibition of discrimination. At the time, there were over 60,000 people under guardianship in Hungary, which was one of the highest per capita rates in Europe. A 2014 amendment to the Civil Code had entrenched the conflation of legal and mental capacity and provided for both partial and full guardianship. It had also introduced a limited form of support for decision-making for a small number of people with disabilities, but this system is fraught with issues. Among other things, a condition for receiving support is that you are stripped of certain parental and civil rights. In terms of community living, there were at least 25,000 people with disabilities institutionalized in Hungary, and the government was in the process of disbursing hundreds of millions of euros, mainly to the managers of institutions, to build new small group homes. This would expand the system of institutionalization and was planned using EU funds. In 2017, the government offered nearly 250 million euro through 2 calls for proposals for the implementation of these plans. The work on the inquiry request actually began in 2013 as we started to collect this sort of information and statistics and to reach out to national NGOs and OPDs to see if they would support a request to the committee. While almost everyone we spoke to expressed serious criticism of the situation, especially the calls for proposals and the government's so-called deinstitutionalization process, nobody actually felt able to complain to the committee. Their main concerns were fear of reprisals in a context where the government has been known to withdraw funding from critical NGOs, to make intimidating phone calls to activists' family members, to publish blacklists of activists and NGOs, and to raid NGO offices. The year that we filed the request, the government enacted the so-called Lex NGO that, as it turns out unlawfully, required so-called foreign-funded NGOs to register with the government. 2 months after we sent the request to the committee, the government initiated a criminal investigation against Validity for our work exposing torture in institutions. Nevertheless, our relative freedom as an international NGO allowed us to continue with the request when national civil society felt unable to act. So to turn to our arguments and the committee's findings, the request argued that an inquiry was timely, urgent, and necessary, and of course that it met the formal criteria under Article 6 of the protocol, which are very similar to those that were set out by Theodora earlier in relation to the inquiry process under the optional protocol to the CEDAW. After that, there were a couple of legal problematics that we needed to address that were fundamental. Firstly, we needed to reliably demonstrate that the violations were grave and/or systematic. We were concerned that the committee would find itself unable to accept the argument that guardianship and institutionalization met these criteria because they're present in every country in the world and they're generally considered by governments to be an acceptable part of our social fabric. So we made a series of arguments based on jurisprudence from the UN Convention Against Torture, OHCHR guidance, and UN special rapporteurs. I myself had prior experience being involved in 2 inquiries under the optional protocol to CEDAW, so we made our arguments taking into account the exact criteria that Theodora outlined earlier. We argued separately in relation to each article that the violations are habitual, widespread, and deliberate, that they are significant in scale, have severe consequences, and are applied against people with disabilities in a targeted and discriminatory manner. We argued that they result from the direct intention of the government and form a pattern of formalized and regulated discrimination. The committee accepted these arguments and for the first time set out clear criteria determining whether violations are grave or systematic under the CRPD protocol. According to the committee, violations are grave if they are likely to produce substantial harm to victims, leading to further segregation, isolation, and impoverishment. The determination must take into account the scale, prevalence, nature, and impact of the violations. In the instant case, the committee found that Hungary's systems of guardianship and institutionalization were grave violations of the convention, including because they perpetuate segregation, isolation from society. The findings clarified that violations are systematic if they are organized and not random, if there's a legislative framework, policies and practices that adversely or disproportionately affect persons with disabilities, or if there are discriminatory or structural patterns based on impairment. It went on to find that the violations in Hungary met these criteria. The second problematic we tackled concerned the principles of non-retrogression and progressive realization. So the request was filed before the committee had adopted General Comment number 5 on independent living. This meant that we had to provide our own analysis of the content of Article 19 and the various rights that it guarantees. And because Article 19 is a hybrid right containing elements of economic, social, and cultural rights, its implementation is subject to the principle of progressive realization. That is, that states are not required to immediately implement these rights completely. We were very concerned in the request to establish clearly that the 30-year timeframe Hungary had put in place for its deinstitutionalization process was not in conformity with the requirement of progressive realization, and that some elements of Article 19, including the right to non-discrimination, were immediate obligations for the government. We also wanted to clearly draw a distinction between the principle of progressive realization on the one hand and the prohibition on retrogressive measures on the other. We argued that building the new institutions and the enactment of the Civil Code Amendment on guardianship were in fact steps backwards rather than progressively forwards. The committee found that the evidence showed insufficient progress, both in dismantling the system of guardianship and in achieving community living. Concerning guardianship, they recommended that the government abolish the provisions of the new Civil Code and move expeditiously to adopt a system of supported decision-making. They also recommended that the government, with full involvement of OPDs, strengthen plans to achieve community living with sufficient resources, concrete goals, a reasonable and defined timeline and indicators, and independent monitoring. So the entire process before the committee took almost exactly 3 years from submitting the request to publication of the findings, and we filed multiple submissions in that time. In late 2017, we were delighted that the Hungarian Civil Liberties Union and the European Network on Independent Living both asked us to request the committee to formally include them as complainants in the process. After we provided an oral briefing to the committee in Geneva, they decided to formally establish the inquiry in 2018. Later that year, the government agreed to allow the committee conduct a country visit, but then decided to postpone it until early 2019. Validity, the HCLU and ENIL provided supporting information to the committee before and during the visit. The committee then carried out 200 interviews on the ground and received over 2,300 pages of documentation. The committee also reached out to the European Commission to interrogate them about their decision to approve the use of EU funds to construct the plan's new mini institutions. The committee adopted its findings in September 2019, but didn't make them public for another 6 months in order to allow the government time to comment. Both the government's comments and the committee's findings were finally published in April last year. But even before publication of the findings, the inquiry had already had a significant impact. Our initiative to submit the request alone and later support from ENIL enabled HCLU, the national NGO, to take the step of joining the request despite the risk of reprisals. In addition, the development by the committee of the criteria for assessing grave and systematic violations advanced their jurisprudence significantly and clarified the requirements for those seeking the initiation of an inquiry in the future. The request allowed us to provide the committee for the first time with clear, comprehensive information on the misuse of EU funds to fund human rights violations. The outreach by the committee to the European Commission clearly also had an effect. In June 2020, we were informally made aware that the European Commission had initiated an audit into contested funding streams in Hungary and was considering imposing financial corrections directly as a result of the inquiry findings. The government subsequently suspended 178 million euros of the proposed fundings. And this month, we were informed by the Commission that the institutions will now not be built. We recently published a Hungarian translation of the findings and have been actively raising awareness of them in Hungary and internationally. The committee required the government to send a follow-up report within 1 year of the end of the inquiry, which the committee then promised to send to the EU. Now, to our knowledge, this has not yet been submitted by Hungary, but the Hungarian government is due for periodic review before the CRPD committee, probably next year. And we've already submitted information to the committee on implementation together with HCLU, the national NGO. The European Union is also coming up for review before the committee, and we will be actively engaged in this process as well. So I'll leave it at that. I wanted to say that I'm happy, of course, to answer any questions, and Validity is happy to provide legal advice or support to anybody or any NGOs or other civil society actors who are interested in submitting requests for inquiry under the optional protocol. Thank you.
Thank you very much. And unfortunately, now it's impossible to organize questions and answers from speakers because time is over. But I would like to pass the floor to Marine to know perhaps some comments that people share in the chat. Marine?
Thank you, Anna. So actually, it was mostly question that we received. There was also a question about whether the event will be available afterwards. So yes, we'll have the recording and all the material. In relation to questions, I can maybe read them, but also what I suggest is that I send them to speakers and that we collect all the replies in a document to send to everyone.
This is great. So perhaps you can tell us the questions just to know it.
So one question was about the number of the pending cases before the CRPD committee. So if there are a lot of cases that are still going to be considered. Another question was more specifically about the Tanzanian case mentioned by Juan Ignacio, to know what happened after the committee gave its view, whether there were any changes in the country and also at the personal level for the victim. And really to know how the protocol are changing policy and practices at the country level. Then there was a question whether there is any opportunity for people with disability in any region. So for instance, in Sub-Saharan Africa. So I'm guessing in terms of sending complaints or doing an inquiry. And then the last two more questions. One was about whether NGO who have special plaintiff status can bring a case to the CRPD committee without being authorized by a individual. So maybe that's a question I can send later on to Theodora for clarification.
Okay, so thank you very much for all these questions from the participants. As it was mentioned by Marine, what we can do is offer the answer by the speakers to the person interested to the different questions. And but now we don't have more time for continuation, so we need to close this webinar. I would like to take this opportunity once again to express our gratitude on behalf of IDA and on behalf of EDF, from my side, also on behalf of the CEDAW committee, for this important contribution and discussion today in relation with the importance of protocols from the United Nations system for women and girls with disabilities, which is here fundamental. As we saw, there are no any inquiry in relation with women with disabilities made by any committee, and in this regard, perhaps we need to work a little more in this issue also. But because there are some consideration of women with disabilities in the different inquiries made, for example, by the CEDAW committee in different countries where the situation of women with disabilities were considered. So perhaps we can explore the chance to work a little more on inquiries, also with another webinar in the future, which is also the best way to know better how we can use these protocols to ensure the rights for women and girls with disabilities. I would like also to express our gratitude to the people who made possible these webinars, such as, for example, the interpreters, of course, the sign language interpreters, the persons who were involved for offering us the subtitles, a personal assistant, perhaps helping women with disabilities to be part of the participation, for example, and all of you for your attention today in this important event. For sure, very soon from the EDF, IDA, and also from other civil society organizations, we were offering new events also to reflect about how to improve the situation for women and girls with disabilities in our region and outside of our region. Thank you for your work. Thank you for your attention, and see you all very, very soon. Take care.